As many of you know, myself and Attorney Griggs, the president of the Georgia chapter of the NAACP, have been covering this case against Fani Willis and Nathan Wade throughout the whole entire process. Approximately 2 weeks ago, we sat in front of the courthouse and pretty much talked about the fact of law and where we thought this case would go. Many of you did not agree with our assertion, but the law is what it is. So, as many of you know, on Friday, Judge McAfee, who is the judge who is overseeing the motion to dismiss DA Fani Willis and her entire prosecution team, including Nathan Wade, issued a final report. And in that report, he pretty much said that the defense, which is the team covering Donald Trump, did not prove their case. They did not meet the burden to show cause where DA Fani Willis and attorney Nathan Wade did anything wrong. Now, we have standing by attorney Gerald Griggs. We're going to get into it again as we always do. Attorney Griggs, welcome. And tell me, do you think this was the right decision?
Yesterday, Judge Scott McAfee issued his order on the motion to recuse and disqualify the district attorney and the district attorney's office by the defendants in the Trump election interference case. And so Judge McAfee, in a 23-page order, basically stated, one, in the finding of fact, there was not sufficient evidence of an actual conflict necessitating the disqualification of the district attorney under the standards set by Williams versus the state, which is a 1988 Supreme Court case here in Georgia, and also reaffirmed in the Reed case, which is a 2022 Supreme Court case, both which state in order for disqualification to be proper, there has to be proven one, actual conflict, that two, materially disturbs or causes issue with the rights of the defendant. So there had to be some type of financial benefit or something like that. He found that there was no such evidence presented by the defendants and thus dismissed their motion to disqualify. But then he also went a little further in his order and basically stated that based on the evidence that he heard, there was a air of impropriety, as he put it. There was the hint of impropriety, and thus he gave the district attorney's office a choice. One, they could either recuse themselves, the entire district attorney's office and the DA could recuse themselves, or they could remove the special prosecutor, Nathan Wade. And so after the order was issued at 8 o'clock yesterday morning, around 3 o'clock, the special prosecutor submitted his resignation to the district attorney, at which point she accepted it. And so now we are in the position that the case can proceed as ordered by the judge based on his ruling from yesterday.
I came across some information where it appears that the judge had made his decision, his final decision, about a week ago. But yet, on Wednesday, he announced that he was going to dismiss 6 of the charges against Donald Trump. And I wonder what was the strategy behind this, knowing that he had already made his decision. Why did he wait 2 days prior to Friday?
I saw tweets about the possibility that he made the decision last week, and that would make sense because this was not a hard call in any form or fashion. And my hope is that, politics are playing no part in this because the judicial branch is supposed to be above politics. That's why judges are elected nonpartisan. But I did say that it foreshadowed what he was going to do. When he dismissed the 6 counts, it foreshadowed that, one, the indictment would not be dismissed, and two, there would be no disqualification of the district attorney's office. So it appeared that he was trying to split the baby. And, in a case like this, you shouldn't be trying to split the baby. You should be ruling on the side of the law. And, with regard to the dismissal of the 6 counts, 3 of which were against the former president of the United States, they were basically on technical grounds. A special demurrer basically states that they did not plead with specificity the charges against the defendants, to wit, the defendants could form a defense merely by looking at the charges. So they could always go back to a regular grand jury, reintroduce a new indictment, which specifically says which part of the Georgia Constitution they believe that the defendants were trying to violate through their oath of office by soliciting an elected official to overturn the results of this election, the previous election, which is very simple. I mean, it wouldn't take much. So I think that what possibly could be happening is that he was trying to play, both sides and making sure he threaded it right down the middle. But it is concerning to hear, and I'm hopeful that that's just conjecture, that he didn't actually make his decision last week, because if he made his decision last week, he should have announced it last week. But this is a highly politicized case. It's a highly watched case, and he wanted to make sure he dotted all his I's and crossed all his T's, and he did that in this particular order. Now, there was a lot of commentary on things that were not a part of his actual ruling, which is curious and always leaves you open to appeal, namely him even mentioning the need of a gag order. Now the defendants are probably going to push for one, but again, if you gag the state, you got to gag the defense and the judge. And so I just think it could have been a 5-page decision that said, look at, the Williams case, look at the Reed case. They didn't prove any conflict, actual conflict. There's no law that says, the hint of impropriety or the specter of impropriety. That's not the law. The law is you have to prove an actual conflict, not the shadow of a conflict or some other term like that. So it was curious to see it took this long for him to decide, but he did get the ruling correct.
I know that this wasn't the ultimate thing that DA Fani Willis would have hoped to have happened, but it could have gone a lot worse. There were a couple of things in the judge's final writings that were very, very scathing. One that stood out to me was an odor of mendacity. That's what he wrote. There's an odor of mendacity. Now, I'm not sure if he was referring to DA Fani Willis in the story with Nathan Wade, or was he really referring to attorney Terrence Bradley, who was all over the place in his testimony and in my opinion was not credible at all. But the odor of mendacity, for those of you who don't know, mendacity is being untruthful or just outright telling a lie or a falsehood. So what say you as it relates to those words?
Miss Willis and Special Prosecutor Wade were not impeached. In order to impeach somebody, you have to prove them disworthy of belief. Now, there may have been some questions about dates and time frames and, whether or not things were paid for with cash or things like that. But it's up to the defense to disprove that. And if their star witness was Terrence Bradley, I'm not sure we could believe anything that was said on the stand by Mr. Bradley because he was, like you said, all over the place. So, the odor of mendacity comment was interesting, but again, it seemed like a lot of dicta. And yes, the judge is the fact finder in this case, and clearly, based on the facts that were in front of him, he could not determine an actual conflict. And I think based on the evidence that was before him, he didn't need to even take this up under advisement and draft a 23-page decision. He just needed to rule from the bench that they haven't met the Williams standard, which is what I said on this program and many others, that under Georgia law, this was a complete waste of time. It was not a motion that should have ever been brought. It was further not a motion that deserved an evidentiary hearing that was a fishing expedition into people's backgrounds. Now, do I think that there will be fallout from this particular motion and the evidence that was adduced? Yes, because there are some serious concerns about ethical issues that will be taken up in another setting, whether that's the Senate hearings or the bar. But it had no place in a criminal motions hearing on a RICO indictment of individuals who were charged with interfering with the election. I really don't see why we were even talking about the district attorney's love life in a courtroom.
Former President Trump has several cases against him. One in New York that's been pushed back, I believe, until sometime in April. And then the case that's obviously moving forward with DA Fani Willis here in Georgia, that may happen sometime in mid-August. If either one of these cases presents a guilty verdict, would that then disqualify former President Trump for running or holding office?
It won't disqualify him because under the United States Constitution, there are only certain qualifications to run for president and to actually be president. And one of them is not being a convicted felon. Now, you can't vote as a convicted felon, but you can still run and hold that particular office, which is interesting in and of itself. So he would still be allowed to run for president, but he'd just be running from the Department of Corrections. And if he was to win, he would be serving from the Department of Corrections in Georgia. And so it would be interesting, and the first time in the history of this country, that if he's convicted, a convicted felon will be serving in the office of president from a jail cell in Georgia. And trust me, if he's convicted of this, I don't foresee probation. I don't foresee house arrest. I don't foresee anything other than substantial prison time, because at this point, you have been convicted of a RICO conspiracy. And there's already precedent for prison sentences for people that are convicted of RICO conspiracy in Fulton County. And I don't remember anybody getting probation after trial. So it's one of those things that we're witnessing history in real time. We're witnessing legal jurisprudence in real time. And it's very concerning that people aren't taking this as serious as it really is. I mean, these are felony offenses. There's an allegation that somebody tried to subvert the will of voters in Georgia, and people are pretending like this is not a serious felonious accusation that could result in large jail sentences. And we have to remember, 4 people already pled guilty. So there's evidence that this occurred, and there's individuals who've already agreed to testify. So I think that we are watching this in real time. I think that the sideshow will now subside, and we'll get back to the business of the actual practice of law and determination of what the facts are with regard to the alleged attempted conspiracy to overturn the will of the voters in 2020.
So at this point, how does DA Fani Willis and her team move forward? And then also, what happens to Nathan Wade as it relates to the money that he's been paid? Will he be required to refund the money or any part thereof?
I think first and foremost, people need to understand that this case is very much still active, and it's on a motions calendar. It can easily be transferred to a trial calendar and pushed forward for trial. The judge's order was very clear. If Ms. Willis continues on the case and Special Prosecutor Wade recuses himself, which he's already done by resigning, case continues. So as far as what happens to Fani Willis with regard to this case continues, and the defendants need to get ready for trial. And what I would say is that what the defendants failed to realize is now there will be no deals on the table. I do understand that Mr. Roman allegedly had an offer of misdemeanor probation and First Offenders Act, but his lawyer was the one that filed this motion. So I don't know if that that offer will still be on the table for Mr. Roman. I know that, Ms. Willis will follow the law. She's followed the law all the way to this point in this case and others. And so I think that people need to, 1, calm down, 2, recognize that this is a criminal matter. The district attorney was never on trial. It's never a trial for Fani Willis, and that it will proceed. She has requested that the case be tried as soon as possible. I think there was a tentative trial date floated out there for August of some sort. So I fully expect the case to continue and be tried at some point this year. And, as far as the monies that were paid to Mr. Wade, he earned those funds. He actually did a lot of this work leading up to this. And, so he's going to get paid. My understanding is there are grievances that are filed with the bar. Those will not be public. There will be some decision by the bar. If there's no action taken, you won't hear anything more about it. There may be action taken by the Senate as far as investigations, but they don't have enough votes to impeach and remove. So it's much ado about nothing. And the defendants need to get ready because they're the only ones whose liberty is at stake. There's a lot of conversation on the internet and mainstream media about the soap opera that played out in that motions hearing. But according to the judge, that has been foreclosed. Now, there is a possibility that the judge could allow an appeal to happen pre-trial, which again, he would need to grant an interlocutory appeal. So he need to give them a certificate of immediate review. If he does not, and that's discretionary, if he does not give them a certificate of immediate review, this will not be reviewed by the Court of Appeals or the Supreme Court until after the trial and only if there's a conviction. So I fully expect that Judge McAfee will order this case to continue, will not grant a certificate of immediate review for anyone, and this case will be set for trial sometime this year and will be tried.
So there you have it. We've been covering this whole entire process since the very beginning. And I like to thank Attorney Gerald Griggs, president of the Georgia chapter of the NAACP. I'd like to thank you all for watching. And remember, MVP TV, we're always there.